indicated interest in joining one of IDAC's new subcommittees. Some other stakeholders who heard about this webinar, who we've publicized it to, are joining us as well. For everybody, for the folks who I don't know yet, my name is Sarah Jacobson. I'm the Executive Director of the Public Defender Association of Pennsylvania, but more importantly, I chair the IDAC here at PCCD, here with Malia Brink, and our committee co-chair, Kate Cacciamani, is here as well. Some of the folks, hi Kate. Some of the folks that are here in part because the IDAC has gotten to the place in its work where we are forming subcommittees. That work of recruiting people and forming the subcommittees is still a thing that is happening. So there will be more communication out to folks about that soon. But if you are here because you're interested in one of the IDAC subcommittees, you're in the right place, and just know that you haven't missed anything in terms of the formation of subcommittees. That's still happening, and thanks to everybody who's volunteered and signed up to join the subcommittees. A reminder for the IDAC members, our next meeting is November 12th. In the meantime, we'll look forward to forming the subcommittees, kicking off a couple of those meetings, hosting 2 webinars, including today's. And for the IDAC members, keep in mind as you're listening to this webinar and the forthcoming one from folks out of the Michigan Indigent Defense Commission, the questions that we're going to be talking about at our November meeting, specifically, where do we want to start in terms of standards, and what process do we want to use in terms of reaching the initial standards or our next standards that we come up with. Our hope is that the conversation today and our next webinar will help inform that discussion and help us reach some sort of accord as to those questions. Again, like, where should we start with next standards, and what process should we use when reaching standards? So I'm pleased today to welcome Malia Brink, who will be speaking to us. She co-authored the ABA's revised 10 Principles of a Public Defense Delivery System and RAND's National Public Defender Workload Study, both out last year. And she will be discussing both the publications, the process to reach them, and how they've been implemented so far. Malia is currently a senior policy attorney with the Deason Criminal Justice Reform Center at Southern Methodist University's Dedman School of Law. I thought Temple Law had a long name, but SMU may have us beat. There she directs projects on initial appearance and charging times. Before joining the Deason Center, Malia served as the Counsel for Indigent Defense to the ABA Standing Committee on Legal Aid and Indigent Defense, and served as Deputy Director for the ABA Escalade's Public Defender Workload Study Projects and Misdemeanor Court Observation Projects. She's taught at Penn Law, American University School of Public Affairs, Georgetown Law. While at American, she served as the Public Defense Project Director at the Justice Programs Office. She's also served as the Director of Institutional Development and Policy Counsel for NACDL. She began her legal career as the Jerome J. Sestak Public Interest Fellow at Wolf Block, and as staff attorney at the ACLU in Philadelphia. Also, back before all of that, clerked for the Honorable Norma L. Shapiro on the United States District Court for the Eastern District of Pennsylvania. So all kinds of interesting things in Malia's background. She's just the person to have this conversation with us today. During the presentation, I'm going to ask that everybody keep your computer, your phone muted. We're going to broadly save questions for the end. There's going to be a break kind of in between the 2 segments. We're going to start by talking about the ABA 10 principles and follow that up with the National Public Defense Workload Study. There's going to be time in between those sections for a couple questions, but most of the questions we're going to save to the end. When we get to that point, we'll ask that people use the raise hand function and then come off mute to ask questions. But you can also, along the way, put questions in the chat. Malia may be able to pick up some of those questions as she goes along, or the PCCD staff will help us curate that all at the end. But that's a lot of me talking, and you're not here to see me talk. You're here to listen to Malia. So with that, Malia, thank you for doing this. Really appreciate this. I'm going to hand this over to you.
Great. My absolute pleasure to be here. I think normally I would say, oh, it makes me feel very old to hear somebody go that far back in my resume. But the important part was that I have Philadelphia roots and a deep and abiding love for all things Pennsylvania, because my family is in kind of a more rural part of Pennsylvania. So I am excited to be here, excited to do what I can to help you all start in this standards process. I don't know if I can even see the chat, so I may not pause and get to chat questions. But as Sarah said, I'm going to start by talking about the ABA 10 principles. And then before I switch and talk more in depth about workload, there'll be a moment where we can talk about standards development. And I am going to try and come at this from the perspective of this group, which is thinking about like, how do you set standards? Public defense standards are old. They are as old as Gideon. The first set of ABA standards on how to provide defense services, meaning like publicly funded defense services, go back to 1967. They actually haven't been updated in a while, and they are still remarkably applicable to today. And there are standards for everything in public defense. So guidelines for negotiating and awarding contracts, specific guidelines related to death penalty cases, right? And then guidelines that relate not only to public defense, but to just what should defense lawyers be doing. The defense function standards come to mind. Some of you may be familiar with kind of the standards that came out of a first major kind of national convening on public defense that occurred in 1972. Those were the National Advisory Commission standards. They are the source of some of the very old and original workload standards. And then groups like NLADA and NAPD, the National Legal Aid and Defender Association, the National Association for Public Defense, have put out different kinds of standards. NLADA tends to put out kind of more ABA-like comprehensive standards around things like defender training, negotiating contracts, kind of very administering assigned counsel programs, very specific aspects of public defense administration. NAPD tends to put out kind of opinions on very specific things. You may be familiar, for example, with their kind of write-up on support staff ratios. But there are a slew of public defense standards out there. The ABA 10 principles were originally created in the early aughts and adopted in 2002. They were designed for policymakers. They were designed to provide experts and non-experts alike with a super easy way to assess public defense delivery systems. But honestly, it was about communicating the needs of public defense to policymakers. And how can you boil down these kind of critical, important components of public defense? And they were really successful. Providing Defense Services is an ABA booklet together with all of the standards and the commentary and the footnotes. It's like this thick. The ABA 10 Principles was a lovely little pamphlet. And so it really kind of took off. They have been recognized by public defense agencies, courts, legislatures, and highly used by policymakers. The Attorney General Eric Holder, when he was Attorney General, called the 10 principles the building blocks of a well-functioning public defender system. I like to say that they are kind of the conditions precedent for good public defense. You could potentially meet all the ABA standards and then still just kind of had a not very good lawyer who didn't maximize their time, maybe, but very hard to think about good public defense happening unless all of the 10 principles are met. And that's how they were approached. The approach was system-based, right? The 10 principles are not about what an individual defense lawyer owes to their client. They are about how do you create a public defense system. They were not intended to be specific to any particular type of system, meaning a public defender office, court-appointed counsel system. They were intended to address all types. And then the kind of those building blocks. How do you make sure that you're getting what you need from your policymakers to make good public defense possible? And so that is how they were kind of chosen. In 2000, right before the pandemic, we started the process of trying, actually, it probably goes back to 2019. We started the process of trying to revise the ABA 10 principles. To do that within the ABA, we thought they needed a revision because it had been over 20 years. Our goal was to actually get it done for the 20-year mark, which would have been 2022. The pandemic and honestly, the process threw that off a little bit, and they came out in 2023. But there were a lot of changes to public defense practice in that 20 years, right? Technology, having to look at, the phone dumps, the jail calls, the body cams, right? The rise of issues like, and the acknowledgement of issues like cultural competency, understanding more the importance of social histories, as well as the increased use and role for support services and the rise of all of the different problem-solving courts efforts to kind of within the criminal justice system either divert or address causes of criminality. At the same time, we came at the revision with that same set of goals in mind. Didn't make it into the principles unless it was a foundational building block of a public defense system, meaning it had to address the system. And it had to be one of these things that we thought were really conditions precedent for good public defense. So those commitments of the original principles. The group that came together was appointed by SCLADE to try and revise the 10 principles. It was a diverse group of public defenders from across the country, public defense experts, and academics, led by Norm Lefstein, who many of you may know, who kind of, I think, was like the father of public defense. I mean, he ran one of the Ford programs that introduced public defense in juvenile just shortly before Gideon and well before there was a right to counsel in juvenile cases with Galt. The principles, once redrafted, were circulated for comment both within ABA entities like the criminal justice section, the section on civil rights, social justice, as well as the Standing Committee on Legal Aid and Indigent Defense. That's really important because if you can get the buy-in of the criminal justice section, that's not just defense lawyers, it's prosecutors and judges, right? Similarly, SCLADE, while its primary goal is to address legal aid and indigent defense, essentially lawyers who serve poverty populations, that committee is frequently, there are judges on the committee, people who are active in their A2J commissions. It gives us a very wide reach for input. And then comments from all of we call them the alphabet soup, but the defender associations and core places that use these 10 principles to talk to policymakers on a regular basis. And really represent the core of the community that do this work. So the National Legal Aid and Defender Association, the National Association for Public Defense, National Association of Criminal Defense Lawyers, and then the Sixth Amendment Center, which uses them to evaluate systems. The revised principles were adopted in 2023. Importantly, every single word of them, including footnotes, has the force of ABA policy. Probably isn't important to you, but if you're trying to get the ABA to do something, it's important. And while the original commitments of the 10 principles have definitely been preserved, you will see that there are principles that are brand new, that reflect kind of the modern era. And so what I'm going to do right now is just walk through the principles. We're going to talk a little bit about specifically what changed, like what the new sections are. But really, I'm just going to focus on some themes because I know you're thinking about what standards might be most important to you. And so principle 1 in both 2002 and these principles is independence. It was very important to people that not move. The focus on independence is to be independent from political influence and judicial authority. Which is not to say that the judge doesn't have a role in public defense, but rather that role is kind of the same as the judge has with regard to either retained counsel or the prosecuting agency and its lawyers, right? so that there is no group that is exerting undue or disproportionate authority over public defense. So legislators are always going to have the power of the purse. They have for the DAs as well, but public defenders, no any more than DAs, should not be politically influenced in terms of their decisions on how they either move in an individual case, choices they make about what they kind of say, all of those key pieces. To maintain that independence, there is a recommendation that a nonpartisan board or commission should oversee public defense in any given jurisdiction. So there are lots of public defense commissions that are that govern public defense across the country. And actually, one of the places that they do not have that level of independence is in the federal system. They're cited within the AO. And there is actually, I think, a bill coming shortly to introduce a commission into the federal system. There is more in the new principles about what does this mean at kind of the local or kind of smaller level. So the selection of the public defender as well as lawyers and staff should be based on merit, right? And there is an increased emphasis on diversity and inclusion in these principles and a reflection of the community served. Really importantly, the notion that public defense providers should have recruitment and retention plans in place, both to ensure that there is appropriate staffing, that's possible, as well as to ensure diversity at all levels of the organization. And then finally, this was an add, neither the chief defender nor staff should be removed absent a showing of good cause, right? And that's just really getting at one of the very obvious ways in which independence is commonly violated, where a public defender does something. They seek to stop case influx because their lawyers are overloaded and they don't feel like they can comply with ethical obligations, or they say something about current bail practices, and there is a repercussion. You all may be familiar with the Al Flora case from however long ago in Pennsylvania, right? But a very specific requirement that chief defender and staff should not be removed absent a showing of good cause. Principle 2 addresses the funding structure and oversight, and a lot of this has to do with the state's role in public defense. So super simple. There's not anything in Gideon about who should pay for public defense, but recognizing that these are state criminal charges, the bulk of what's happening in state courts, there should be adequate state funding, but also state oversight. So there is a portion of this obligation that rests squarely with the state. I know that's new in Pennsylvania. I remember coming up in a system where there were very distinct county systems that really didn't talk a lot to each other and no state money flowing into public defense. And then the structure of public defense itself, which is meant to balance kind of involvement of the private bar, but with the expertise that a public defense office creates. So where the caseload allows, meaning where the caseload is sufficiently large that a public defender office is warranted, public defense should be a mixed system, right? Meaning a public defender office supplemented and augmented by additional public defense providers, whether that's usually court-appointed counsel, who can handle overflow and conflict cases. Structure, funding, and oversight also addresses compensation, saying that they should be appropriate, and this is important, comparable to other publicly funded lawyers. In the prior 10 principles, there was a real stress on parity with prosecutors. That's still there. It still says something about parity with prosecutors. But to be honest, in the 20 years since the original 10 principles were passed, there's been actually a static level of funding for public defense and prosecutor salaries, or a drag just in criminal law as compared to other publicly funded lawyers. And so this was a real intentional effort to say you need to look at the funding for attorney general offices, for your insurance division. You need to think about this as a critical aspect of law and not just kind of allow criminal law salaries to fall off. And then very importantly, because there's a lot of emphasis on this kind of rise of support staff, other provider Attorneys, meaning court-appointed counsel, should be paid a fee that reflects both overhead costs, like whatever they're required to cover in their fee, as well as payment for work. And then the social workers, investigators, experts should be funded and compensated in a manner consistent with this principle, meaning how are they being paid in other parts of public service? And there should be parity of resources in general between public defense and prosecution. Principle 3, control of workloads, we're going to talk about more in depth once I get through all the principles. But the core concept here is one of ethics, that workload of public defense providers has to be regularly monitored and controlled to ensure competent and effective representation, right? And that comes right out of the ethical standards. Workload should never be so large as to interfere with the rendering of quality representation or lead to a breach of ethical obligations. Right there, it's kind of very tied to the ethical obligations, and a lot of this language comes directly from an ABA ethics opinion called 06441. At the time that the old principles came out, this was really important because there was a pervasive belief that because public defenders are assigned by the court, they didn't have the same obligation as private lawyers to control their workload. And 06441 essentially said, no, this requirement of effective and competent representation, and embedded in that the necessary belief that you have to control your workload and limit it to only those cases that you can handle fully, does apply even to public defenders. This principle goes further and says that there should be workload standards to try and set numerics based on reliable data to ensure that there isn't kind of a systemic violation of workload that you don't kind of reach excessive workloads on a system level. That jurisdiction-specific workload standards may be employed when developed appropriately, meaning with a reliable format, but that national workload standards should never be exceeded. That obviously refers to the National Public Defense Workload Study, which came out right around the same time as the principles and is cited here. And we will talk more about that and what it says in the second half of this presentation. So what happens if workloads become excessive? What is the kind of responsibility of the public defense provider or the system? And the short answer is you're obligated to take steps necessary to address the workload. That can be notifying the court or other appointing authority of unavailability until you can get the workload back under control. Or if necessary, withdrawing from current cases. It's in that order because that's the ethical obligation. Your obligation is dominant to your existing clients. Your obligation to future clients is broken first. If you have to withdraw from cases, and there's actually good guidance on this in the ethical rules in terms of what your obligations are to those current cases if you have to seek to withdraw. Principle 4 is data and transparency. This is entirely new. This is an entirely new principle, but to ensure funding and compliance, you need data. You need to understand what's going on in the system. And that data needs to be provided to people who are making policy-making decisions, whether it's about budget or anything else. It needs to be provided to them in a manner that is both reliable and collected appropriately, but also protects client confidentiality. So the system has the providers have an obligation to collect data, and the state has an obligation to regularly review that data and implement necessary improvements. So public defender providers should collect reliable data on caseload and workload, right? Major case events, use of support services, including investigators, experts, social workers, as well as outcomes and monetary expenditures. So part of this is about good governance. It's about where are we spending public funds. And part of it is about oversight, if you refer back to Principle 2, and allowing for good oversight. In addition, public defense providers should collect demographic data on lawyers and other employees. This is about making sure that your systems reflect the community served. It also is the case that the ABA's position is that you cannot collect demographic data on clients unless you're willing to do it for yourself. So the ABA has extraordinary policy on the collection of demographic data from judges, right? Every place you think the system should really reflect communities. And this portion of this principle really reflects that commitment. The collection of demographic data on clients is about ensuring that services are meeting the needs of your diverse clientele. So how do you figure out how many different kinds of translation services you might need unless you're actually talking to your clients and figuring out what their primary languages are, but also being able to look at your data and looking at disparate impact to understand whether there are challenges you should be bringing. And then this is the real transparency piece. Data has to be shared. So public defense wants to often, it's like, okay, with collecting data, sometimes it's a little harder to say it's got to be shared. With other relevant entities, that includes policymaking entities, commissions, possibly the legislature. It also means that it should be made publicly available, and that's in accordance with best practices. The aggregated portion of this is one part of those best practices, meaning no client identification in here. Everything is aggregated and therefore anonymized, but comprehensive. And these best practices are a moving target. So there's a little bit of a footnote here that describes kind of current best practices, but recognizes that those are going to be kind of an evolving standard, particularly as data gets more and more robust. Principle 5 is about the cost of public defense and eligibility. States that public defense should be provided at no cost to any person who's financially unable to obtain adequate representation without substantial burden or undue hardship. This is a very big deal. There is a footnote here that really talks about the fact that it may be kind of different by charge, right? What it costs to get private representation for a misdemeanor is very different from what it costs to get private representation in a homicide case. Our standards should really reflect that. Oftentimes, eligibility standards do not reflect that on their face, but do in practice. It's like one of these things that everybody knows. Everybody gets appointed someone in a felony case if they don't have a lawyer, but that jurisdictions also should not charge an application fee, which might dissuade someone from seeking public defense services, nor should people who qualify for services be required to contribute or reimburse for those services. Persons should be screened for eligibility in a manner that ensures the information remains confidential. The process for applying should be not complicated or burdensome. And it should really kind of take into account other determinations of what are effectively indigency that are frequently done before someone ever enters the court system. So whether they're on public assistance or they're in custody, right? These things should be kind of assumptions of eligibility absent contrary evidence. Early and confidential access, principle 6, which is about when appointments should take place. So counsel should be appointed immediately after arrest, detention, or upon request. Prior, this is important. So we talk a lot about counsel at first appearance. To have effective counsel at first appearance, the principles acknowledge that you have to meet, be able to confer with the client and prepare to address pretrial release prior to that first court appearance. And counsel should have confidential access for that meeting for a full exchange of legal, procedural, and factual information. And then waiver of the right to counsel has a very specific process. This, again, is really coming directly from ABA ethics opinions, that before a person can waive counsel, they have to be provided actually with an opportunity to confer with a defense lawyer who can explain the dangers and disadvantages of proceeding without counsel. The sense within the ethics community and the ABA is that really judges and prosecutors are not great at describing what defense lawyers do and explaining what it is that they would be waiving. And if relevant, the implications of pleading guilty if this person's intending to plead guilty immediately, including the direct and collateral consequences of a conviction. Principle 7 is making sure that the experience training, that the lawyers in a public defense system have appropriate experience, training, and supervision for the types of cases that they're handling. So a public defense provider's plan for the assignment of lawyers should ensure that they have the experience and training to match the complexity of the cases to which they're assigned. Obviously, you should be required to attend any necessary community education or other training to enhance skills, and that training should be provided to public defense providers at no cost to the attorneys or other staff. Attorneys in a public defense system need to be regularly supervised and evaluated, and that those evaluations should take into account national, state, and local standards as well as ethical obligations. Finally, this is that the training should be required to ensure that public defense providers can effectively represent clients affected by poverty, racism, and other forms of discrimination in a culturally competent manner, meaning they need to have a lot of training to understand the client community, and like an ability to screen for certain things, whether that is about substance use, mental health, but often things like communication issues. And that's kind of a critical part at this point of public defense, and being able to communicate effectively with your client and have them be able to help in their defense. They also need to be specifically trained on raising legal challenges based on racial or other forms of discrimination, and trained to recognize biases within a diverse workplace, so that those can be raised on behalf of the client community. Vertical representation, Principle 8, is about ensuring that the client has a robust relationship with their lawyer. So to develop and maintain a relationship of trust, it should be, to the hugest extent possible, the same lawyer who continuously represents the client from assignment through disposition and sentencing. That's what vertical means. Representation by that defense lawyer can be supplemented by specialty counsel, such as counsel with expertise, whether that's immigration, mental health issues, forensics. And similarly on the appellate side, right, because there's a right to counsel through the direct appeal, the lawyer assigned the direct appeal should represent the client throughout that direct appeal. I want to make one note on this, which is that Principle 8, vertical representation, is often viewed as being in slight tension or conflict with this desire to have the earliest possible representation. And so there is a footnote here that talks about the use of bail units to ensure robust counsel at first appearance, and says that that's in some ways a way of supplementing representation with people with special expertise, so that you can kind of use specialty lawyers for initial appearance. And it has some information about kind of how you ensure still a relationship of trust and good transition between lawyers. That information would also apply for the inevitable, which is somebody leaves and you have to reassign all their cases. And then Principle 9, which we decided to call the essential components of effective representation. You might say that this really kind of addresses the use of support staff and their increased role, but also really fundamentally, there is a tension within public defense about the four corners of the Sixth Amendment and where you have a right to counsel, and the kind of general view of ethics, which is that you take the client you have and have to adopt as your priorities their priorities. And this principle comes squarely down on the side that public defense, even though limited in the nature and place of representation to the criminal case, and whatever expansions of that have been provided under state law, is required to still adopt a client-centered approach. Understanding the client's needs and working with them to achieve their goals, which may mean that in a particular case, you have to, if the client's view of that criminal case is not that the most important thing is whether they did it and whether they're punished, but rather that they be allowed to stay in the country or retain custody of their foster care children, that is kind of the approach you have to adopt. And this also talks about the importance, the critical nature of investigators, social workers, mitigation specialists, experts, other specialized professionals who may be necessary to meet the needs of those public defense clients. Such services, super importantly, their determination of need and their funding should be controlled by the public defense provider. It should be part of public defense budget to be able to have access to these people. And you shouldn't have to, for example, go through a court to be able to access them. That in itself is kind of a violation of independence. Most other parts of the community, private lawyers, usually prosecutors, don't have to do that if they want to use these types of experts. And that contingency funding should be made available to support access to these services as needed, meaning if that funding runs out and within the public defense budget and there's still need, there's got to be kind of a way to access contingency funding. Further, public defense providers should address civil and non-legal issues, for example, things like housing that are relevant to their clients' cases, but that doesn't mean that they're offering direct assistance, right? Still recognizing the four corners of the Sixth Amendment, but whether it's through establishing collaborations or referrals, they should be able to address or seek to address the core needs of their client community and like what is really keeping the client in their criminal case. And then last, but certainly not least, and this is was Principle 10 and the original principles as well, public defense providers should be included as equal participants in the legal system. They are in a unique position to identify and challenge unlawful or harmful conditions adversely impacting the client community, and they have that obligation. But more importantly, they need to be able to weigh in on legislative or organizational or structural changes that would impact their client community. So for example, if the court is going to change how dockets are flowing, and they're going to bring in some group of people to kind of think through how to make dockets more efficient, public defense should probably be at that table. More importantly, this comes up all the time whenever a legislature thinks about adding a whole series of new crimes or upping sentences, right? To the extent that changes result in increased defender workload or responsibilities, what has to come along with that is adequate funding to address those changes. Okay, so these ABA 10 principles, which again, if you think of them as conditions precedent, structural conditions precedent to good public defense, they have some very logical uses, right? They are often used for system evaluation. Anyone who's read a Sixth Amendment Center report on a jurisdiction, they basically walk through the 10 principles and judge kind of what exists in the system versus the 10 principles. But they also are often used to create jurisdiction-specific standards. And I know that you're talking to Michigan, but those come up, right? And if you look at the standards, I only put the first 3, but if you look at the 8 standards that Michigan has come up with, they usually correspond to something within the 10 principles. One of the questions that I commonly get asked is, if you're a jurisdiction and you're starting with the 10 principles, do you start at principle 1 or do you start at do you start like Michigan did with education and training? Do you start with things that most affect the client, like access and appointment time? I think the answer to that is complex and maybe very jurisdiction specific. I think that Michigan, and you'll have to hear more about kind of how they started, right? But I think education and training was something that everybody could agree on, get on board with, right? There's a way in which if you're starting a system to put in place standards that are sort of enforceable, it's really important to have the first ones be maybe less controversial. But you could also go for biggest impact, or you could go with, and this has been the case in another jurisdiction I can think of, right? They had a bunch of legislators who were really on board with beefing up support staff. And so their initial pieces on specific enforceable standards had to do more with support staff ratios and the way that affects workload. And so I actually want to pause here before we move to talk about kind of principle 3, which is workload in more depth and in the context of the national study, and see if anybody, I'm going to stop the share for a minute and see if people have immediate questions.
Thanks, Malia. We got a couple questions in the chat here. I'll start from the top. Sarah had asked, how important are the footnotes to the ABA 10 principles? I know you mentioned earlier that the full text, including including the footnotes, has the force of ABA policy. Can you talk a little more about the footnotes?
Sure. So I think a lot of the things that got put in the footnotes are structurally dependent. So for example, rather than address in every single principle how exactly it might apply if you're using court-appointed counsel versus full-time public defenders, sometimes that got put in the footnotes. Sometimes I mentioned one of the footnotes that I think was particularly important, which had to do with the use of kind of early appearance units as a specialty unit where the person who appears at first appearance may not be the trial lawyer through the case, and that kind of inherent tension between wanting early access and wanting vertical representation. Where we had things like that, we tried to put that kind of explanation or thoughts in the footnotes. I hope that that explains it. I mean, they do have the full kind of force of ABA policy, so there's a way in which they're kind of on equal par, but that is just sort of the explanation of what made it into the text versus the footnotes. Can I actually like add on to that and say, there are some big things that you might see as omissions that we did not address. And I think one of the things that was really important about the 10 principles, and it goes to something I actually just said at the end about how do you start, right? It's hard to prioritize them. There's not a lot that we think is incredibly controversial in the principles. And so there are places where there isn't really a consensus within the field. And those issues tend to be omitted within the principles. If you look at providing defense services or the defense functions, they may get more robust discussion. And I will give you a very concrete example. Who is screening for eligibility? Right? Passive voice hides all manner of ills. It does not say. The only thing it says is it shouldn't be the presiding judge, but it doesn't actually say whether it should be like a court officer or the defender itself. And that's because within public defense, there are a lot of people who say the criteria should be set by courts, but defenders should be screening because then that confidential information remains within the defense community. The problem there is historically, there have been some incidents where screening is used as a way of decreasing caseload. You kick cases that are sort of borderline and just don't take them because it's a way of controlling. It's not an appropriate way of controlling caseloads, but that is a concern of another part of the defense community is like, would you kind of use screening in a way that might not actually be at the highest benefit of the defense community? I would love to say that public defenders would never, ever, ever, ever do that. We usually believe that, but it has actually occurred, so it's hard to ignore. And so you might notice as you take a real deep dive into this, that there are some things that are not addressed. Should I just move through some of the questions that are in here?
Yeah, the second question that came in was, can you speak to the question of aggregated data? So I believe this is in relation to Principle 4, data and transparency. Right. Would that standard preclude county by county breakdowns of data? And Marlene, you asked this question, just correct me if I'm wrong. You may have been asking this in relation to the law that establishes IDAC. So just for your awareness, Malia, if there's a provision stating that county specific data received by the Indigent Defense Advisory Committee shall remain confidential, and that the committee may release aggregate data at its discretion in its biennial report. So just open to your thoughts about that transparency standard.
Right. And I think aggregated data, if the county by county data is of sufficient breadth, that it itself is still kind of within the standards of anonymizable, right? If that makes sense. And I'll tell you a little more like kind of my thinking on this, but it sort of matters how robust the data is. If you are, for example, there is one case of a type in a particular county, then breaking data down by case type and county may de-anonymize information on that one particular case. And you need to be aware of that as you look at this data, but most systems produce county by county data. And in fact, when we get into the national workload study, I'll show you a system that kind of produced data by, it's actually kind of their regional offices to look at the comparisons. And I think it's a very legitimate use of data. I think a lot of these questions become very specific to the data set that you have, because at the end of the day, the question is, have you kind of you have to keep an eye, particularly with this data, on client confidentiality. So, if there is only one case of a type, this comes up a lot. Actually, you'll see in a lot of state reports, the highest level cases, whether that's death penalty cases or LWOP cases, get aggregated and reported statewide as opposed to county by county, because there are so few of them. And so there are some choices along this line, but it really is about, ultimately in this moment, the protection that you're most concerned about ethically is client confidentiality. I hope that answers the question. But like if you're reporting, for example, investigator use by case type, and there's one case of a case type, you've just disclosed whether a client had access to an investigator or a social worker, or, consulted 3 mental health experts. And that's the kind of thing you have to be careful.
Yeah, that makes sense. And Marlene said, thank you for that clarification. The next question we got was, how does Principle 9 interact with the principle that talks about application? I have potential clients who call with open arrest warrants or who have been contacted by law enforcement but are indigent. Large volume of calls. What is defense system encouraged to do?
Right. Okay. So you have clients with open arrest warrants, but have not necessarily so when you talk about application where it says arrest, right? It says, this is directly out of the ABA standard. I can go back to it, but it actually says as soon as possible after arrest. I don't remember what the second piece was, or request. And so, right, this comes up in jurisdictions because the process by which formal charges are filed differ widely across the country. So if you get someone who for some reason knows they're the subject of a grand jury investigation. I live in DC. We have 6 grand juries going at any given moment. It's really fun. It may be that there is work to be done. And if you can evaluate for indigents and start work at that earliest phase, the point of early representation is that there are things that are lost. I don't know a single public defender who's gone in search of, video that somebody thinks might exist from an ATM or something else, and it's been overwritten because the case didn't get filed until a year later, and it's on a 30-day cycle, or sometimes as short as a 48-hour cycle. So I think there is a tension about that. There is a volume issue about that, but in general, the principles call for as early involvement of defense counsel as possible. And I hear that it is a huge volume of calls. And that really is the biggest single issue. And trying to evaluate whether they are really under investigation or just paranoid at that point is actually really hard. And I understand that. But the question of whether you can identify whether they really are potential clients, and whether you can get an arrest warrant. I mean, if you can get an arrest warrant knocked down, somebody doesn't ever have to face arrest, right? Best possible outcome, probably less work for you in the long run. And so that's really the issue with early entry of counsel. That probably didn't help other than to explicate exactly why the question came in, and I apologize.
Thank you. The last 2 questions may be related, so I'll just read them together. If a county can't comply with ABA principles, what mechanisms are in place to assure compliance? And is there any way to make the standards mandatory? So, if you've seen anything nationally or state by state, county by county, interested in your experiences and thoughts on that.
Right. So like all ABA standards, these are advisory. On the other hand, right, these standards, because they are intended to be kind of building blocks, foundational, right, that is how they are presented. When you think about Strickland and the adoption as to what constitutes kind of baseline public defense, right, effective representation of counsel within prevailing professional norms. while the ABA standards have no enforcement mechanism, they have been recognized over and over and over again as being foundational to those, that they really are the kind of professional norms. And that has come up in litigation about systems. So when you look at systems that get sued for poor public defense, oftentimes what is being cited is kind of the ethical obligations and the ABA principles and other ABA standards and what is not happening. And so very specifically, if you think about Hurrell Herring in New York as one of the most significant public defense kind of failure to abide by the Sixth Amendment, right, for these counties and the state. One of the major points put out was the assignment of counsel timing, and that people did not have counsel at first appearance. And probably the most foundational ruling that was made in that case was making that mandatory. And saying that the violation of that was indicative of just Sixth Amendment violations across the state that then led to kind of mechanism to enforce it. There's a commission and they have standards, and those standards are enforceable. And that is what usually happens. From the ABA flows kind of a manner of adopting these standards as being widely accepted, and then they get adopted through some state mechanism that makes them mandatory. And that question, Lisette's question on how to make the standards mandatory, I am going to punt entirely to my friends in Michigan. Because that is the process that they have walked through. Is you have these standards, they exist. They're pulling from the ABA standards. They are making them mandatory and enforceable. They are bringing with it funding from the state to try and achieve compliance. And I think to John's question, that's a really important part. One of the ways that you assure compliance is to assure that when you set a mandatory standard, there are mechanisms in place to assist counties at reaching compliance, both evaluating their level of compliance and then assist in reaching it. But I think the next hour that you spend with Michigan will be right on those topics, and they are far better positioned to talk about them than I am, because they are 7 years into a lived experience.
Thanks, Malia. I'm not seeing any more questions in the chat, but if anyone has anything else they'd like to add, we can raise your hand and I'll call on you, or we can move along to the second segment and save those questions for the end.
Yes. Great. So let's talk about the National Public Defense Workload Study. I know that you all are familiar with it. I'm going to move through these topics quickly because I am cognizant of our time today, and I want to make sure that you have opportunity to ask questions that you have about this. I think my most important thing that I can do here is to give you a little bit of background and methodology for the study. You are likely familiar with Paul Heaton's work on the results and the application of the study in Pennsylvania, but I will walk through a little bit of application. I'm going to try to fly through that section, and if you want me to slow down, somebody unmute and tell me. And then really what I want to get to is how are other jurisdictions applying the standards. Why set workload standards? Well, we just talked about the 10 principles, and I mentioned in the 10 principles that it comes directly from the ABA ethics opinion, right? But it really comes back to the model rules of professional conduct, which every single state have adopted in some fashion. Rule 1.1 states explicitly that competence as the core skill of lawyers requires not only legal knowledge and skill, but thoroughness and preparation reasonably necessary for that representation. And that is all about time. You cannot be thorough and prepare without time, which means that you can only take so many cases at a time. And then if you look at diligence, Rule 1.3, there's an explicit comment that requires that a lawyer's workload must be controlled so that each matter can be handled competently, meaning that you have enough time to be thorough and reasonably prepare for that representation. Model Rule 1.7A2 would suggest that the failure to control workload is in essence a concurrent conflict, meaning you cannot undertake representation of more clients than you can competently represent, because when you do, the time you spend for one client conflicts with the time that the other client needs. And so that excessive caseloads or workloads create a significant risk that the representation of one of your clients will be materially limited by the lawyer's responsibility to another client. So the history of public defense workloads, there's a lot of lore to this. In 1973, the National Advisory Committee standards, which I talked about when I was talking about the early public defense standards, came up with annualized numbers for attorneys, 150 felonies a year or 400 misdemeanors a year. It's also 200 juvenile cases or 200 mental health cases. And those were ORs. So if you had a felony attorney, their max new assignments was 150 a year, misdemeanor 400 a year. The legend is that that was created on the back of a napkin at an LIDA meeting in a bar in California. And really was as much about like, you know, I mean, they didn't have data. So it was a bunch of chief defenders sitting around thinking about what they thought was reasonable, and candidly, because it was trying to make its way into this National Advisory Commission report, a little bit what they thought was palatable in 1973, right? And so almost from the jump, those NAC standards are criticized both for a lack of defensible methodology, but also a failure to distinguish between case types, because there is nobody in public defense that thinks that a low-level burglary is the same as a homicide case. 150 low-level burglaries are not the same as 150 homicide cases. And so there's kind of a built-in assumption about maybe a mix of caseload that's not really defensible or understandable based on the standard itself. And so a number of jurisdictions kind of set to try and create better workload standards. And as you moved into the aughts, the early 2000s, there was a real effort to kind of capitalize on increasing data availability and come up with workload standards through an empirical and defensible way. So the National Public Defense Workload Study comes online after those efforts have been underway for almost 15 years. And so we start with being able to benefit from all of those jurisdiction-specific studies. So the first thing that the National Public Defense Workload Study Group did was to undertake a systematic review of all the existing workload studies and their methodologies. And the first thing we determined was that, you know, if you think of this as sort of a meta study, we're going to study all the studies that exist and see if you can say something new for the field that would apply across the board, even where those specific studies didn't apply. You have to see kind of what data exists in all of those studies. That's how the scope gets limited to adult criminal. The jurisdiction-specific studies, not all of them addressed all of the other areas of practice. And where they did address the areas of practice, some of them addressed them in very cursory ways, whether that was about juvenile or appellate, or in places where the public defenders are taking on parent representation, or in the very few jurisdictions where they managed to take on both child and parent representation in dependency cases. The other piece was that all of the studies that we looked at that were current, like recent, and used some variation on a Delphi panel. A Delphi panel is really just a way of quantifying expert opinion on a topic that otherwise kind of defies being reduced to numbers. So you gather a group of people who all have significant expertise, and you try and ask enough questions to get them to a consensus, because it's not something you can just count. And the Delphi method was developed in the mid 60s, I think, if some people date it as early as like the late 50s, by the Rand Corporation. And it's been used in any number of fields. My personal favorite report was that back in the days when we didn't have really good information on what was happening behind Soviet lines, there was a Delphi panel assembled to try and determine a number that the US would use to estimate how many nuclear devices the USSR had. So it gets used across the board in a lot of things. Very importantly for this work, it's used frequently in judicial workload studies. And so the methodology for the National Public Defense Workload Study took a lot of lessons, not just from the existing public defense workload studies, but also from existing judicial workload studies, and recognizing that this methodology was used by the judiciary itself. So if you think about the kind of constituencies to which you have to kind of sell this, The judiciary is a big one, and their familiarity of it made it even more a good way to kind of look at this. So here's a map of the jurisdictions that had workload studies at the time, jurisdiction-specific workload studies at the time that we started the National Public Defense Workload Study. Sarah mentioned that I was involved in some of these. The group of people working on the National Workload Study were involved in a bunch of them. So Sglade at that point had done 7. I was kind of most involved in Indiana, New Mexico, and Oregon, which I was involved with from start to finish. And I had a small hand in Colorado and Rhode Island. So I had touched 5 of the 7. My colleagues at RAND had done a number. My colleague, Cynthia Lee, who was on the National Workload Study, had participated in, I think, 3 of the 4 that NCSC had done. And then there were a couple who'd been done by outside agencies, but even like the Texas study, which was done by a group at A&M, used ABA consultants to help them with methodology. So the results of the National Public Defense Workload Study, it looks at 11 adult case types. So taking that, if you think back to NAC, right, one of the major criticisms is a felony is not a felony. The National Workload Study divides adult criminal work into 11 case types, ranging from felony high LWOP all the way to misdemeanor low. And importantly, for public defense work, counts probation and parole cases, violations, separately from the underlying criminal case, because as defense lawyers are very well aware, the factual patterns involved in a probation or parole violation have nothing to do with the underlying case. So what you're fighting about often, it requires its own separate investigation. The results, rather than the 150 per year, 400 per year annualized assignment measure, use a case weight. A case weight is just a name for average hours per case by case type. So if I say a mid-level felony case, on average, 57 hours per case. Why use a case weight? Because fundamentally what this is about is competence and diligence, which are focused on the time needed to do the work. That time is constructed from estimates that are based on very specialized, segmented lawyer activities and tasks. The lawyer activities and tasks used in the National Caseload Study are over here on the right. They start with client communication and care and go all the way through sentencing, mitigation, and post-adjudication. These are kind of ways of breaking down what an attorney does in an adult criminal case that would be familiar to any defense lawyer across the country. It's also activities for which there are very specific standards in the defense function standards, what an attorney should be doing in a case that we can point to and base kind of conversations around how much time is needed to do this work. And those standards really anchored those discussions and therefore anchored kind of this study. So constructed from time estimates that are broken down by attorney task. And while a felony is not a felony, right? Felony low cases do take less time than an LWOP case. One of the wonderful things about a case weight is that while you can distinguish the time needs by severity, you can then reconstruct a caseload that's very personalized to an attorney, because it may be that a single attorney doesn't exclusively have one type of case. You may have a homicide unit where they do, but in smaller jurisdictions, the same attorney is going to have a bunch of felony low cases and may have the one murder case that's open in that jurisdiction. And they may also have DUI cases. And they're certainly going to have probation and parole violation cases. And by using a case weight that's specific to hours per case, when you're assigning those cases, you can look at just the hours that an attorney has and deal with mixed caseloads. You can also deal with part-time attorneys easier because you're just reducing the total number of hours they have per year. And yet, as you assign a case, you can estimate how long that case is going to take. These are the case weights, again, meaning average hours per case of that case type that the National Workload Study came up with after looking at all of those other jurisdiction-specific studies conducted from 2005 to 2022, and then convening a national Delphi panel to try and come up with a consensus of time needs based on all those activities in each of these types of cases. It was an incredibly, incredibly fun discussion. I want to walk through not so much the methodology of how we got there, but how you apply the National Public Defense Workload Study. Before I do, I will say that having been involved in several of the states, this would apply equally to how you apply a state-specific study. The first thing you have to do is map historical caseloads to the case type. If you do a jurisdiction-specific study, your case typing might be different. It might be very specific to your jurisdiction. The National Workload Study worked off of the 17 that existed to come up with the most common case types. You then project your caseload for the next fiscal year by case type, and then you compare that to the calculated total attorney hours. You get the total attorney hours needed for your projected caseload. So this is kind of how you go and apply it to your caseload to understand how many attorney hours you need, which is the first step. So you have to map all of your cases by highest charge to these case types. Here are the definitions, right? National Workload Study provided 3 definitions, one based on description, one based on a projected sentencing range, and one based on kind of examples of highest charge that we thought would fit within that particular case type. There are places where these don't match. So for example, serious property crimes, maybe an arson, the possible sentence in Pennsylvania may not be 3 to 15 years. Maybe it's more than 15 years. And then you have to decide, does that belong in felony high other or felony mid? And that's kind of a choice that gets left to the jurisdiction that's applying it to think about how well it fits with other cases of those case types. So where does that arson, arson cases where the highest charge is arson belong? These are the rest of the case types and their kind of 3-pronged definitions. Importantly, the definition of a case is person-based, not charge-based. So one defendant in a single event or closely related series of events, and all of the charges that relate to that single event or closely related series of events for that defendant is a single case. And you then map that by highest charge. So if you have individual 1 charged with armed robbery and firearms violation, the case is mapped as armed robbery. It's not that the firearm violation ceased to exist, but you don't stack kind of time based on charges. It's viewed as an armed robbery case. And that's why, some people look at them and say that the charges look so like, I don't need this many hours for a mid-level felony case. Well, it's an average. You don't think that any particular case might hit that number exactly. You might have a case that really, that's the highest charge is mid-level felony, but the person in fact has 20 charges that relate to it. And that's an incredibly complex case. And it has to take into account that one case that goes up on appeal, comes back, has to be retried, as opposed to the case that is relatively simple and settles in a much earlier phase through a plea agreement. And that is what makes up an average. So where you might think of as an average is like a bell curve. Frequently in public defense, I would suggest to you that it's not a bell curve. There are like 80% of cases that come in below average and then like outliers that really pull up that average. Once you map your cases by case type, here you have a fictional jurisdiction's historical caseload data for the last 5 years. I will say that a lot of places use what's called a rolling average to kind of project ahead, meaning they're just going to average out these numbers across 3 or 5 years, and that's going to be their projection. The other way to potentially do it is that, you know more about what's happening in your jurisdiction. This would be a projection that might be based on kind of, that 2020, 2021, those dips are really about COVID. And your expectation is that the caseload for low felony is going to continue to grow slightly in your jurisdiction. And it's essentially a guesstimate based on the last number of years and what has happened, as opposed to just doing a rolling average. For places that use a rolling average, judges often use a rolling average to project caseload, 3 or 5 year rolling average. A lot of them are dropping 2020 and 2021 from those rolling averages. Once you have your projected caseload, you just multiply the number of cases by the hours needed to come up with hours needed across your system. It's really simple. It's really basic math. We joke all the time that yes, we ask attorneys to do math, but we don't ask them to do anything more complicated than multiply and divide. Once you do this across all case types, so there are like is a 2025 projection across all case types. This fictional jurisdiction is based on a real jurisdiction. And so this would be a legitimate 2025 projection for all these different case types. You can get total hours needed in the system to provide public defense to all these case types. We are not assuming that all these cases will open and close within the year, so much as we are assuming that if you provide for the hours needed in any given year, that in the next year and the next year and the next year, some of these cases may go on 3 years at the highest level, LWOP cases. Some of them will close within the year very easily. But the assumption is that if cases are coming and going at roughly the same rate, what you need to do is allot for an hour's worth of cases, a year's worth of case in every year. In this jurisdiction, they need just shy of 1 million hours of attorney time to cover the state's total criminal adult caseload. Once you know the hours needed, you can understand current staffing by FTE and calculate based on that FTE the amount of time that's available for casework, and therefore calculate total attorney hours in the system to compare to the hours needed. So I'm going to run through this for a jurisdiction that's very simple. It's a statewide public defender system with that's their calculation of their projection. And this is their kind of attorney situation. They have 326 attorney FTEs, but they have a number of attorneys who take no caseload. So they're a chief PD, 2 assistant PDs, and a training director. They also have 6 division heads who have a minimal caseload who we're just going to take out entirely. And they have 30 attorneys who don't do adult criminal work. They do juvenile work, mental health work, other work. And so that leaves you with 286 adult criminal FTE. And then you're going to take out the people who are really partial FTE from that. So if you have felony unit supervisors who have a 50% caseload, or misdemeanor unit supervisors and 50% of their work is supervision rather than a caseload. In this jurisdiction, they also have 20 first-year attorneys in the adult criminal division. And then they count those because of the intensive training requirements for the first-year attorneys as an 80% FTE. And that would leave us in this jurisdiction with 274 FTE who are responsible for adult criminal cases. There's been a lot of talk. The ABA studies use 2080 hours per FTE available for casework a year. That is incredibly conservative. It's literally 40 hours per week, 52 weeks a year. Everybody knows lawyers don't only work 40 hours a week, but on the other hand, it doesn't consider vacation, training time, regular meetings, outreach work, travel time. Different jurisdictions have set different work hours. I always suggest that jurisdictions look at their judicial workload study, because there is an equivalent of this, which is a judicial work year. It tends to range from 1,200 to 1,600 hours per year that's available. Washington State recently set 1,650 as their hours available per FTE in public defense. But we're going to assume 2080 on the conservative side. And this is basically the staffing math. You take your projected caseload that gave you the hours needed, and then you divide that by hours available FTE, and you get the total of number of FTE needed. You subtract the number that are currently there, and you will find out if you have too much or not enough attorneys to handle your caseload. In our fictional jurisdiction, you'll remember that there was just under 1 million hours needed of attorney time. So that's how this ferrets out. There's that 922,000, just short of 1 million, divided by 2080 hours available per FTE. They need 444 FTE. They have 274. They have a very significant deficiency. Oftentimes when jurisdictions go to do this, they find out that they have a lot of data that they need in order to apply the national study that they don't have. They may or may not have their historical caseloads. They may or may not have them by highest charge such that they can map them. It's always great to have time data, because that would let you set a very legitimate base number for the number of hours available for casework. They may not even have staffing data, right? Places that are particularly reliant on contracts have a hard time coming up with FTE numbers for their contract defenders because they don't know how much, what percentage of their time they're spending on public defense and how much of an FTE to count them as. It requires common definition. So in a county by county system, if a case is counted differently in different jurisdictions, in different counties, that becomes a problem. And then, as I said, you have to map them by case type. So some of the potential results of different jurisdictions that have tried to apply the national study is that they end up having to do a data inventory and think about data systems upgrading so that they can keep better track of both their staffing and their cases. But a number of jurisdictions are effectively applying this. In New Mexico, they actually use the New Mexico workload study, which is a study that I worked on, to come up with a 5-year plan to close their adult criminal deficiency. It included additional resources, but it also included a plan to get some case types out of the system. I want to go back really quickly because this is based on a particular jurisdiction, and just look at the 2025 caseload projection. Right, this is one of the really interesting things for me coming out of this is that we're getting jurisdictions caseloads across these same case types from across the country. And one of the most interesting things to me is where is the time need? And you will see that the bulk of the time needed in this system of this 922 hours does not come from these highest and most serious case types. It comes from low felony, misdemeanors, and probation violations. And that is incredibly important data because a lot of times I think public defense is being told, well, you're asking us, you know, when we talk about potentially some changes that would involve removing some cases from the system, you can have hard data on which cases you're talking about asking them to remove and whether or not the changes that you're asking for really affect violent crime. Washington State, they have adopted the National Public Defense Workload Standards by the Bar Association, and they are now taking them to the Supreme Court. Somebody asked, how do you make standards enforceable? The Bar Association has voted that the National Public Defense Workload Standards should be the workload standards applicable in Washington State by 2027. It was a 12-to-1 vote. And so they have switched from what was previously a standard that was based on the national advisory standards, 300 to 400 misdemeanors a year or 150 felonies a year, to just adopting the National Public Defense Workload Standards. They actually adopted them both for adult criminal and for juvenile. And then here's a really interesting version of applying this to show different resource needs. This is Maryland from the 2023 annual report. They applied it across their 12 different districts to show the differential staffing needs and deficiencies. And this happens all the time. I was actually just working with a public defender who runs an extraordinarily large city system who did an application of the National Workload Study and found out that he had some defenders that had 0.7 of a caseload and some that had upwards of 5 times a caseload because we don't typically assign cases in public defense based on how many cases you can actually handle. Sometimes they're just assigned based on what the courtroom that you're in and whatever docket the judge is handling. And if you look at those attorney tasks that this study is based on, you'll find out that not a lot of them take place in court. Most of the attorney work in public defense is not taking place in front of judges. And so to base it based on the workload of a courtroom creates really wide disparities, which is part of what you're seeing here. In California, it's a county by county system. They actually have fewer counties than Pennsylvania. There are 58 counties in California. The biggest thing they wanted to do was come up with a single guide on how to apply the National Public Defense Workload Standards, how to map California criminal code to the caseload types that are in the National Public Defense Workload Study, so that when counties tried to apply it, and a lot of the kind of more urban counties in California are using this to ask for budgets, they could get cross-county comparisons that would be kind of apples to apples rather than apples to pears and oranges. I am happy to stop this and take questions. I am sorry that I couldn't see the chat during any of that.
Thanks, Malia. We do have one question in the chat. Please, folks, feel free to type your questions in the chat, or you can use the raised hand feature on Teams if you'd like to unmute and ask a question. John had asked, for public defenders active in practice, do they believe the case weight system is reasonably accurate?
Yeah, well, I will say, and I did, and that one of the things about these studies is that it comes directly from practice. So in the jurisdiction-specific studies, the case typing comes from, it's usually a focus group of actual practitioners in the jurisdiction. And then the Delphi panel members are all active practitioners in the jurisdiction who have quality representation, reputations among their peers and good experience. And that's who was part of the national study, right? We not only kind of brought together consolidated data from all of those studies, which was drawing on all of those Delphi panels, right? All of those panels of expert defense lawyers across those 17 jurisdictions, but then bringing together in person a national Delphi panel from across the country that was, nominated for practice by peer organizations. And then we reviewed, it was a long process of figuring out who would get into that room. That would be, and you can look, their names are in the national study. This is not hidden. You can go decide whether you think they are good qualified lawyers to have made these estimates. But that is who it is coming from. And if you've ever tried to deal with 40 lawyers in a room trying to come to a consensus, it's robust discussion. And hard fought. And then the degree of consensus is a data person term, but it was a coefficient of variation. And if you have a data person, they can review the coefficient of variation we use to say, like, did they think it was enough of a consensus? I know that Paul Heaton actually, when he did the application in Pennsylvania, went behind those numbers to actually look at the coefficient of variation and even kind of downgraded some of them, which was a little controversial. But, he did that, and he took a very conservative tack. And all of that is possible because one of the things I will say is there is nothing hidden about the National Public Defense Workload. It is that long for a reason. We put absolutely every piece of data in there to be picked apart by the field as much as they want to. And to date, there's been, I have to say, I was ready for it to get ripped apart. I did not think this was going to be my highest and greatest achievement. I thought this was going to, get kind of a lot of controversy and that I might be in debates for the next year about whether it was viable. And to have people like Paul Heaton, who I respect tremendously, go behind it and come up with the conclusion that this is worthy of application and to take it and to do something like what he did in Pennsylvania with it has been extraordinary. And then to be able to come to you and say, here it is, it's an open closet. You can, look at every stitch and pull at threads and decide for yourself. And there are, jurisdictions that have had some issues. So for example, in Washington State, they did not like that 2080 number and they moved away from it and they explained why they did. But for all that it has been subject of debate and criticism, the case weights have not been much. Almost everybody agrees with the hours numbers, particularly at the highest level of cases. To the extent that there are problems with the case weights, most people will point to that the discrepancy between current hours and the hours in the case weights that they struggle the most with are at the misdemeanor level. And if you talk to public defenders, they acknowledge that that is because there's almost no investigation happening in misdemeanor cases. Just to kind of build on that, and I know we're coming to an end, but one of the things that I will say about, one of the things that I do think you can do in thinking about the National Public Defense Workload Study is that it was adopted based on existing support staff levels. And if you look at those case tasks and the attorney case tasks that it was based on, there is more work there that could be moved to support staff if those people existed in the system. And one of the things that I am thinking about when I'm thinking about an application that I'm working on in California is what would it do to those case weights if we could move some of that time to support staff and off of attorneys. Because nobody in the room had adequate support staff by any stretch. And everybody in the room would say some of that client care time could be moved to social workers if you had them, right? Just by way of a specific task example.
Yeah. I'm going to skip the one question that came in because I think what you're just mentioning now kind of relates to Kate's question that she just put in the chat here. Taking the public defense workload study information, was there a further study of what is needed in regards to investigators and social workers required to support public defense workload standards?
Yeah, I think there's going to be a lot of work coming on that, Kate. I mean, the work that I'm doing on California is very focused on it. I would point you in the direction. The one place that's done some work that's institutionalized is actually Indiana, where they have a different caseload number, caseload standard, that is based on whether you have adequate support staff or not. And it reduces the caseload standard for places without adequate support staff, meaning they can take fewer cases per attorney.
Marnie Joe asked if there is an update planned in light of constantly changing technology and pandemic changing workforce expectations.
I think that we would all agree that this will need to be updated somewhat regularly, like thinking about our model, which is to think about either jurisdiction-specific workload studies or judicial workload studies. NCSC recommends that they're updated every 5 years, but really the norm is closer to every 10. I know that there are people who I'm not qualified to do the juvenile version of this. I hope there's a juvenile version of this that we start to cover more of the public defense workload, but there is a lot of work that can be done to continually update this work, and that would be awesome.
Sarah, do you want to share with the group here what you put in the chat about PDAP's policy on mapping offenses?
Sure. So Malia spoke a bit about the need for uniform mapping. The Public Defender Association of Pennsylvania formed a subcommittee to look at this, came up with some uniform mapping. We have adopted a policy on that for Pennsylvania public defenders. If anybody wants that, feel free to shoot me an email. I'll send that to folks individually. I will say that the mapping policy we adopted is a little different, not hugely different, but a little different than the mapping that Paul Heaton used in his Pennsylvania specific study. We are very much aware of the work overloads, the data gaps, and data challenges that public defender offices face every day. So our mapping policy was with an eye towards keeping it simple and easy to use and easy to implement in case management software. But so that's yeah. So if folks want that, folks can email me sjacobson.pdap@gmail.com.
And I'm going to just quickly address Kate's second question, which was, did the workload standards take into account body camera video review of now common on most cases? And the answer is yes. It's a huge part of what went into some of the misdemeanor numbers. And there's actually an entire chapter in the report that actually summarizes a lot of discussion that went on in the room about the things that have changed in public defense. I know I'm under the wire. Or over the wire. I'm on the wrong side of 2:30. But I want to address a question that I'm actually shocked I didn't get, which is, does Pennsylvania need to do its own study? Because that's the question that I get every place I go. And the answer is a little bit up to Pennsylvania, but given the newness of the National Public Defense Workload Studies, I don't think you have to do one imminently. It's very expensive. So I will say that a jurisdiction-specific study probably starts at about $250,000. Maryland recently put one out to bid, and I can probably get Sarah that number when it goes through, because luckily all state contracts are public. So I can tell you exactly what an RFP has produced recently. And And I think it's, it's only going to kind of go up just because of the intensive needs involved. But I think one of the real questions about whether you need a specific study has to do with how easy it is to map your case types. Places far more complex than Pennsylvania, like California, which doesn't use lesser inclusive charges, but uses weird forms of enhancement, has a harder time, and there was a link to that study in the PowerPoint, which I will share, has a harder time using the national study than other places. And so if you can actually get data by highest charge, and it's relatively easy to map the highest charge to the national workload study, then I would think that that is kind of a better place to start until and unless you're kind of better able with a statewide organization maybe to think about who would be on a Pennsylvania panel and get organized to do a study and all of those things. They take 18 months to 2 years. Longer if you try and do them in a pandemic. Don't do that.
That's really helpful as we think about our work, though, Malia. Thank you. To have a sense of cost and time.
And the other thing I will say is that they're not all complete. So in Indiana, we were able to do the standard setting, but we were not able to do the part that most people want to get out of the study, which is an application that gives you a concrete deficiency, kind of the work that Paul Heaton did, right? And if the data isn't good enough across all of your counties and it doesn't sync well, and I would say, look at the Indiana study. We did some best extrapolations that we could, but we basically had to say, we can't tell you a statewide deficiency in Indiana. The data is not good enough. And that's a very real situation for a lot of jurisdictions, and one that you should take into account before you go down that road and you end up with kind of standards that probably look fairly close to the national study and not a lot of application to Pennsylvania. So all of that is to say, I love state-specific studies. I've done a bunch of them. I'm a huge fan. People want to pay us to do them. I'm sure there will always be people willing to do them. But I think there are a bunch of caveats to really think about what's the most useful use of your time and effort and priorities. That's a very legitimate question.
So super helpful. Jordan, do you see any other questions?
I'm not seeing anything else, Sarah.
Folks here, anybody with other burning questions for Malia that she hasn't addressed? And she covered a lot of ground, but if you have other questions for her, this is the time.
And I will say I flew through the application because I did get to review the PDAP version, and it's identical to what I said. So you have really good guidance on how to apply the national study already.
Yeah.
And I'm around. I try and be as accessible as humanly possible. As I said, I have Pennsylvania roots and love Pennsylvania. So if you guys need anything from me further in terms of information or more questions I can answer, please just reach out.
I really appreciate that, Malia. And as you heard in the beginning, we're forming subcommittees now. We're still, as you know, at the early stages in the beginning of our work. So we may have questions, hopefully, with some specificity as the work comes together and as the projects come together. But I can't thank you enough for, first of all your work in this space and for explaining that and talking to us today so that folks have a sense of what the national context and landscape is. It totally, really, really helpful and really valuable as we're figuring ourselves out here in early days. So thank you.
My pleasure. Thank you guys for sticking in for so long. I know we're over time. I appreciate you. And yeah, have a good luck. And thank you for all the work that you are doing.
Everybody, thanks for joining us today. We really appreciate your time. As a reminder, this was recorded. I know that PCCD is going to put it out over their emails. PDAP will put that out to folks as well. Hopefully it will live on the IDAC webpage here on the PCCD site also. We hope that folks can join us for our next webinar. It's going to be in about 3 weeks, Tuesday, October 1st from 1 to 2:30. We have Kristen Staley, who is the current Executive Director of the Michigan Indigent Defense Commission, and John Sachs, who was the original Executive Director of the Michigan IDC as that formed, to talk about how Michigan started its work, how it's grown, Michigan started with an initial investment of, it was like 10 or $15 million, and they're up to around 280, almost $300 million of investment. So it'll be interesting to hear how they chose to start in terms of standards, and how their work has grown. Invitation to that webinar will go out shortly, and we'll make sure that as many folks get it as can. And again, thank you so much for joining us. Thanks, everybody. Have a great day.